No, oh, there you go. You was.
All right, good morning. This is Senate Judiciary for Friday, uh, January 7th. And we are taking up first S 183, which has to do with an act relating to midpoint probation review. And we're going to start with Eric Fitzpatrick, who will walk us through the bill.
Thank you, Senator Sears, and good morning to the committee. It's Eric Fitzpatrick with the Office of Legislative Counsel. As Senator Sears mentioned, here to do a walkthrough of S-183, an act relating to midpoint probation. I'm going to go ahead and share the screen so that we can take a look at the language of the bill. But as I'm doing that, and when I get to it, I'll give the committee a couple of minutes of background explanation so we can get a sense of what the topic is and why the issue has come before the committee. As it may seem familiar to the committee, and likely does, that we're returning to this topic because you may recall, and certainly do recall since it was last year, that this is a bill that you passed last year, was Act 24. I'm going to pull that up in a moment. So in Act 24 last year, this is what you see. Does everybody see the screen share right now?
Yep.
Oh, great. So this is Act 24 from last year, and this is when this current system of midpoint probation review was enacted. The system that you created last year sort of built on a midpoint probation review procedure that did exist in law already. So it wasn't like it didn't exist at all, but it was discretionary on the part of the Commissioner of Corrections whether or not to file a motion with the court to discharge or dismiss a person from probation when the person reaches their midpoint. It was discretionary whether the commissioner would file that motion. But you see, what you did last year, you established this procedure on subsection D there, review and recommendation for discharge. It required the commissioner to review the record of each probationer serving a specified term during the month prior to the midpoint. So a month before the person reaches the midpoint, commissioner reviews their, and you'll see the change that you made last year. Not that the commissioner may file a motion, was changed to the commissioner shall file a motion requesting the sentencing court to dismiss the probationer from probation, if the offender, and then you had a few criteria listed there. And the criteria are A, B, and C. They haven't been found by the court to have violated conditions in the previous 6 months, if they're not serving a sentence for sort of a number of violent offenses there, and they've completed their rehabilitative or risk reduction services required as conditions of probation, and that's in subsection C. So you have those three criteria, but they're very clear criteria, not allowing a lot of discretion. So if the person, the probationer, satisfies those criteria, remember the system is mandatory. It's not discretionary anymore. Mandatory that the commissioner file this motion for discharge from probation. So the issue is being revisited now because of a court decision, which we'll talk about in a moment, in a case called State v. Lott, a trial court decision by Judge Trevorrow that was decided on September 20th. So just a couple of months ago, where the court had to decide whether this midpoint review statute that you passed last year in Act 24 applied to an offender who was already on probation, or whether it only applied to offenders who were placed on probation after the effective date of the act. See, so the question is really a question of retroactivity, see, because the question of law before the court was exactly that. Is it retroactive so that the probationers who are already on probation can participate in this system that you created of midpoint probation review, this mandatory midpoint probation review, or whether it only applies to people who went on to probation after July 1st, 2021, which was the effective date of the act. So the question, as I say, it's a legal question of retroactivity, and the question of whether a statute applies retroactively is, I'm going to pull up a statute here for you. It's governed by, generally speaking, this particular statute in the Vermont laws, Title I, Section 214. This is the effect of amendments or repeal, the effect of new statutes and what effect they have on current law and people who are subject to current law, et cetera. And this, although the language is somewhat old, it dates from 1969 and hasn't been amended since 1970. Although the language is old, the Vermont Supreme Court has very clearly held, quite consistently, that particularly B2 and 3 taken together mean that generally speaking, statutes passed by the legislature only apply prospectively. That means going forward, unless the legislature specifies otherwise. So the legislature certainly can override this statutory provision and say, oh no, we want to apply something retroactively, frequently done. But the general rule is that unless that's said, or unless it meets a couple of these exceptions that are sort of set out here in the statute, it doesn't meet an exception, or if the legislature hasn't said something specific about it, then the general rule is the statute applies prospectively, does not apply retroactively, but only going forward. Now, that should also be the general concept, probably also familiar to the legislature, because I mean to this committee in particular, because I remembered that just last year also in Act 26, remember the act relating to repealing the statute of limitations for civil actions based on childhood physical abuse. We did exactly that. You'll see subsection E there. You wanted to apply that statute retroactively to cases of childhood abuse whenever they happen. So you specifically said in subsection E, notwithstanding 1 VSA 214, this section shall apply retroactively that occurred prior to the effective date of the act, to abuse that occurred prior to the effective date of the act. You did the same thing if you look up at the existing law from the 2 years ago in subsection D, because when we first got into that topic, it was childhood sexual abuse, not childhood physical abuse. But the same thing had been done. You see subsection D up there, notwithstanding 1 VSA 214, section shall apply retroactively. So that was an express, essentially overriding section 214, the statute we were just looking at, which says, generally speaking, statutes apply prospectively. So you sometimes say, well, notwithstanding that, we want this one to apply retroactively. And you've done that a number of times before. So turning back to Act 24, which was the midpoint review statute from last year, and this is what the court was looking at in the case that I mentioned, State v. Lott, which is, well, what about Act 24? Does this one apply retroactively? And you'll see that there isn't any retroactive language in the bill. There wasn't the language we just looked at, that notwithstanding 1 VSA 214, this new section of law shall apply retroactively. Sometimes it's in the effective date, but again, in the effective date, it just said effective on July 1st, 2021, didn't say anything about retroactivity. And because of that, the court, as I say, looked at the statute, noted that there's no language which overrides the general rule that statutes apply prospectively. Also noted that a couple of the exceptions that I mentioned, the statute does have a couple of exceptions, for example, for legislation that reduces penalties for a criminal defendant. The court said that one didn't apply because the defendant had already been sentenced. There's another one for if the change is only procedural rather than substantive. Court said that exception didn't apply, but barring those exceptions, the rule is the new law applies prospectively, and that's what the court concluded. So I think that if I'm understanding, I didn't staff this bill last year, so I'm not sure, but if I'm understanding the committee correctly, the intent had been that it did apply retroactively. So that brings us to S183. And you'll see there's two things there. I'm going to skip the first change and go right to the second one, because you see what S183 does in subdivision 4 there is it adds to the language that you just looked at. It adds to Act 24 and to this section of law the specific type of language that you also had put in the statute of limitations bills, for example. Notwithstanding 1 VSA 214, this subsection shall apply retroactively to any probationer serving a specified term who had not reached the midpoint of that specified term on July 1st, 2021. So again, that means that it's going to apply retroactively to people who are already on probation, but they haven't reached their midpoint yet, because obviously it only applies to folks who haven't reached their midpoint yet. I mean, that's the general statutory scheme. And then a month prior to that is when the commissioner undertakes the review of their record to determine whether or not to file the motion to discharge. So this essentially makes the statute apply retroactively. So it's quite clear that people who are already on probation will gain the benefit of this new midpoint probation review system. So that's the retroactivity piece. As I mentioned, there's
Eric,
one other. Sorry.
may I
someone
ask
had
a question?
Please.
Yeah. So I am a little bit, I don't know how I read this, but if somebody hadn't reached their midpoint by July, but reaches their midpoint in November, it'll apply to them. Is that very clear here that it will apply to people who?
Yes, I think so. I was thinking that same thing, Senator White, because that universe of people you're describing would still fit under this language, because they also would not have met their midpoint by July 1st.
So what if they met their midpoint in June? Okay, I just want to make it clear that so that we don't get into this again with by not being clear that it applies to everybody when they reach their midpoint.
No, it does not. No, if they reach their midpoint prior to July 1st, I think that the idea was that you don't want to overwhelm the correction system with, everybody who's already reached their midpoint beforehand.
So those people don't qualify?
Yeah, and that's what would have been the case if you had put this retroactivity language in last year.
So
if the people had already reached their midpoint, say they were 80% into their probation,
yeah,
then they had not, I believe the language is that it applies to a probationer who has not reached their midpoint. Yeah, that's right. So they still would have had the benefit of the existing statute, but not this system. No, so that wouldn't apply to them.
well, no, I need to get this straight. So somebody reaches their midpoint in May of 2021.
They fall under the current
They-
law.
They'd fall under this. So
No, if they reach their midpoint in May of 2021, they fall under current law.
Right, the law as it was in effect at that time, exactly.
okay.
Well, they could
So-
have a midpoint review, but it's a may, not a shall. That's the big change.
That's
Go
right,
from may to shall.
right.
So that means that there's a group of probationers out there who have to have a midpoint review. And then there's a group of probationers out there who don't have to have one. It's up to the commissioner.
Correct.
That doesn't quite seem fair.
I'm going to kick in here if I can, Mr. Chair. The rationale that Jeanette is expounding on, I totally agree with. I am not sure what the overall numbers of these people would be. I know that the attempt last year was to protect the Department of Corrections from being overwhelmed. But the reality is the aim of this is actually to get the number of files in a probation officer's filing cabinet out. And if that is the overall intent, I'm not sure how many overall numbers would be talked about if suddenly these people all became eligible. But I think it's preferable to go in that direction unless the commissioner comes back and tells us this is just an impossibility.
Well, I think we should hold that until we hear from the commissioner. I don't know what happened to the Department of Corrections, why, and on any other witnesses. We don't have them on with us, so I don't know what happened.
Senator Sears, if I may,
Oh.
we had the wrong link,
Yeah,
and so I
Commissioner.
apologize for our
Oh, that's
delay
not
here.
your fault.
We are here, though.
Oh, great, great. All right, we'll continue the walkthrough and then you've already heard the first question, I think, would be, should others who are still on probation as of July 1, 2021, and have not reached the midpoint, should they be eligible, or who have reached the midpoint, should they be eligible? That's really the question Senator White and Senator Benning are asking. And last year, it appears that we did not intend for those who had not reached their midpoint to be eligible, because they were already eligible under the former statute with the may. And this basically changed the may to a shall. That's the question. Eric, please, you want to continue?
Yes, thank you, Senator Sears. Yes. So I'll move to the other change proposed in S-183, and this has to do with, remember I mentioned that there's several criteria that have to be met in order for the commissioner to be required to file that motion for discharge. And those criteria we went over, there were A, B, and D now in the bill, but that's the law that you passed last year. They have to find that the court, they have to have been found not to have violated conditions of probation in the previous 6 months, not be serving a sentence for one of these violent offenses, and have completed other rehabilitative risk reduction conditions of probation. But I think Senator Sears noticed in the State v. Lott decision that the program was available even if there were other criminal charges pending against the probationer. I think this was another point that the committee last year would have intended that group of folks not be available or eligible, for the program if they were subject to other pending criminal charges. So this proposal adds that criteria to what has to be satisfied before the commissioner files the motion. So the commissioner has to find before they file the motion, in addition to the other 3 that we just went over, that the probationer is not subject to a pending criminal charge. Now, if those charges are resolved, obviously, and no longer pending, well, then the probationer would meet that condition, and then they could participate, and the commissioner could go ahead and file the motion. So once the charges are resolved, everything is fine. As long as the other criteria are met, they can go ahead and participate in the program. But while they're pending, they wouldn't be eligible for the mandatory discharge system was set up in Act 24.
And my recollection is this was requested by the Department of Corrections.
Yes, that's right. I think there was discussion about that last fall.
Right. Are there any other questions about this? So,
should I pull the screen down, Senator Sears?
Yeah, you could, please. That'll allow me to see that other people are in.
Right.
I want to take a moment just to explain that, unfortunately, Peggy Delaney's brother died last night, and Peggy is not available today, and Mike Barron is pitching in, doing his best to sub for Peggy, and we all miss Peggy and extend our deepest sympathy to her and her family on the death of her brother. That was part of the reason why there was a little mess up this morning, and we apologize. So with that, I will turn it over to Commissioner Demi, and he has with him, I believe, Dale Crook, who's head of the field services for DOC. And I know Dale has an appointment a little later this morning, and so we're picking up with him first. Or you, Commissioner, I mean, that's up to you.
Good morning, Senator. Good morning, members of the committee. Thank you so much for the opportunity to join you today and testify on this piece of legislation. I'd be happy to discuss a couple of the points that we wanted to highlight about this piece of legislation, but wanted to make sure we captured your question right off the top. And so I think the question, as I heard it, was for the population who hit their midpoint before 1 July of 2021, would they fall under this piece of legislation? And I think Senator Sears, your comment was correct that they would fall under the previous piece of legislation. I just make a couple of additional comments on that. The department right now under its authority can review for discharge at any point and file that motion. And certainly we could do that for the population who would fall before the 1 July 2021 date. And you know, it's our current assessment that this would not in fact overwhelm our system. It definitely adds a lift, but certainly doable, I think, from the department's perspective. And other stakeholders may have different opinions about how it is impacting in their systems. But as far as it overwhelming the department's system, I don't think at this point that that is a primary concern of ours. I think the thing that creates the challenge here is the date itself creates those two separate populations that we were discussing. But I would say our own policy on this same topic captures, I think, this same type of intent that you're trying to push, but does not put a date on it like the July 1, 2021 date. So our own internal policy says as soon as somebody hits the midpoint review, if they meet the criteria, we shall file the motion. And so while that may be, it should capture that body of individuals who we're worried about in the discussion. Does that address the questions that were raised on that point?
Yeah, I guess my question would be then, do you need the date of July 1, 2021, just to make the subsection shall apply retroactively to any probationer serving specified term who has not reached the PET midpoint review?
I think by removing the date, it would
Period.
make the process simpler. And I'm not too worried about on our side that overwhelming our system.
That makes me feel better. Thank you, because I think that we don't want to have two different kind of classes of probationers, some who you can decide whether you do it or not, and some that you shall do it. So thank you.
You know, and I think, you know, de facto, that wouldn't be the case because our own policy would capture
Yeah.
those folks, but de jure, it would be the case because the law is different than the policy that we have internally.
Other questions for Commissioner Demi? Dale, do you want to comment briefly? I mean, or take, I shouldn't have said briefly, I misspoke. Would you like to comment?
No, I think the commissioner discussed the concerns that we had. There were two other topics. I don't know if the commissioner wants to talk about them or not, or I can brief them.
Sure.
Okay.
Yeah, Senator, if that issue is satisfied, there are two other topics that we wanted to raise on the piece of legislation. So on the second page in line 4, letter C says that the individual is not subject to pending charges. We would recommend that also include or pending a violation of probation, which would capture anybody who had pending matters that needed to be adjudicated yet. Right now, it just states criminal charges.
Okay.
And then the second item that we wanted to raise for you is it begins on line 8 of the same page. So page 2, line 8. And it talks about when the commissioner is required to file a motion. You know, our reading of this paragraph, we were a bit confused because beginning on line 9, it says, or if the court denies the commissioner's motion for discharge, then the commissioner would have to file another motion once the criteria in the legislation was set forth. That is what the motion we would have filed would have captured in the first place. So it appeared a bit confusing to us that if we filed a motion saying that the probationer had met the criteria and that motion was denied, we would then have to file a motion saying that the probationer met the criteria. So we have two different ways that we would recommend this could be resolved. Either we could take out the prepositional phrase on line 9 that starts, or if the court denies, ending in discharge on line 10, or I think line 12 could be modified to say that the commissioner would file a motion for discharge once the petitioner met the criteria that the court laid out in its motion for denial, or its denial of the motion for discharge. Because I think we don't need to say that the probationer met the criteria that was laid out in the law in that case, but instead would need to be responding to why the court had filed the motion, or I'm sorry, had denied the motion for discharge in the first place.
Well, I mean, that's current law from last year. That was put in last year, so. Eric, have you got those suggestions?
Yep, I jotted them down. Thank you, Senator Sears.
Okay, thank you. Anything else?
Uh,
Can I,
Well,
Senator Nika?
I just wanted to go back to the piece, the first piece we were talking about with regard to the numbers. What is the number of persons who will now be eligible for the shell? Who, in other words, had already reached their miss point. Do you have an idea of what those numbers are?
Director Crook, do you have an idea for the total number?
Not off the top, but I don't have those numbers available, but we can get them for you and we can send them to the committee. It would be everyone on probation that has a term. So it's going to be at least 2,000, if not more.
So, and is each one of those going to require a court review?
All of them would be my guess, no, but there could be a large number of court reviews. The way the language is written, ma'am, is that the department really has very little discretion. And once it meets that criteria, the department shall file the motion, even if the case isn't appropriate, in our opinion. So the state's attorneys the onus really falls on them to make the motion to challenge the discharge. And one mechanism that will have to happen will be a court hearing. So, but I believe that, the judge or the other entities can probably talk more specifically about that.
One question that arises for me, Dale, our commissioner. Currently, you have a real short staff, and probation officers are filling in for it, as I understand it, in correctional facilities and doing other jobs. Is it going to be possible for them to be able to meet this? The bill's effective on passage, so let's assume it passes in early April.
It's going to be coming down as law. I would expect that my staff would do what they can to get it done. We may have cases filed later than we would like, but depending on the number of staff available and able to do it. On our end, it's not a huge lift per case. I think the time will come up is at the hearing. So those that are challenged in having court hearings. Reviewing the case and meeting the criteria is not a huge lift per case. There's just a lot of cases and it's going to be more tracking it, but we can do this. We may be a little slower than we'd like based on staffing patterns, but we will get it done.
Senator Benning.
So Dale, I just want to make sure I'm registering this properly. One of the reasons that we passed this bill in the first place was to decrease the number of people on probation in the hopes that we avoid violations being issued against them, which brought us all back to court. Another was to assist probation officers to get rid of cases in their filing cabinets. I recognize there will be a burden of adding discharge proceedings, but if at the other end of that, it means you decrease the number of cases in your filing cabinet, it seems to be a win-win situation. But I don't want to overwhelm the system either, having said that. So I'm interested in knowing what the numbers are and whether or not you believe you have the ability to meet getting people out there for discharge purposes. I suspect the vast majority of whom would be automatically discharged because the state's not going to put up a stink about them. But in those cases where the state does file an objection, there may very well be conversation between the state's attorney and the defense about whether it's worthwhile trying to go forward in a discharge. So that might minimize some of the impact, but I don't want to leave the conversation without getting a full picture on what you can and cannot do and which would be your preference.
So, Senator Bennington, we already did this last July. Is we were going through and we were looking and reviewing cases and filing cases for review for discharge. So we were meeting the obligation. I'm assuming we're going to be able to meet the same obligation whenever this becomes effective. We may be a little bit thinner, but we will able to do that. I think some of the pressure points kind of came after we filed the motion. We know we did have conversations with myself and Evan from the State Attorneys and Sheriff's Associations and Judge Gerson at the time about how can we, help the system along, because it is an overwhelming. I think it was kind of a shock to the system because all of a sudden the courts were getting flooded with discharges, and I think it happened pretty quick, and they weren't expecting the wave coming on. But I believe that the other entities can talk about the impact that it had on them. I think there was some confusion. For example, we're filing motions for discharge for people in jail pending new charges. On the surface, that didn't make sense, but we had no discretion, so we had to file that discharge. Things like that, I think with some of this language kind of betters that a little bit and kind of adds a little bit more, for lack of a better word, common sense, that it kind of obvious cases that should not be going for review that are pending charges. We're not wasting our time doing that. So there will be less cases that we'll have to review, and our overall population currently has dropped over the last couple of years. So we have less staff right now, but we also have less cases and less cases that we'll have to review. So I'm pretty confident that we'll be able to meet the requirement that is set forth.
When we were developing the bill, that was one of the things that former Commissioner Baker was emphatic about was they shouldn't have to be filing cases where the person's still in jail, awaiting a criminal charge, a new criminal charge. And that's the reason for the language on page 2, line 4. It would, I would hope, would decrease the number of cases where the state's attorney or someone else may object to the discharge probation.
But the overall concept of the midpoint review and removing cases that no longer need supervision, the evidence is pretty clear. Like we don't need to waste our resources on those, because most likely we'll make them worse the longer we keep them on if they don't need our supervision. So the science behind it, everything CSG said about it, like we completely support that. I mean, it's kind of evidence is right there that has been proven. So we're good with the concept. It's, how do we make it work as effective and efficiently as possible for the entire system?
Under what? Yeah.
So Dale, I may have misunderstood you when you said that it was a kind of a shock to the courts, but they don't have to have a hearing for everyone, right? They only have to have a hearing for ones that are challenged. They just have to review and then, so it's timing for the judge, but time for the judge to review, but not taking actual court time. Is that right?
Where I think the initial, and this is kind of in Evan's world, the state's attorneys has 21 days to make a determination if they want to object or not. So the initial wave where they're getting lots and lots of cases and they're trying to go through them and figure out who they need to object to or who they shouldn't need to object to. That was kind of our first run before the court hearing came down. We worked on how to make this simpler for everyone. And we had conversations with Evan that if we were filing motions that we thought were really inappropriate, we would give the state's attorneys a head up to kind of save some of the workload. Like, he's pending new charges. You may want to object to this. Things of that nature. But I was told to our staff, use it very discretionary, only for the ones that are like that. They're pending charges, pending VOPs. They've absconded, like really serious ones, because it's the intent of the legislation is that these cases get reviewed by the court. It's the court's cases, their probation, the court owned. I call it the court owns those cases. We just supervise them for the court, and they need to make the determination. And I think that was a pretty good help for it there to kind of help that system a little bit. But we're working on ways to kind of make it work. Until the court decision came down and kind of stopped it. So.
Thank you.
You're welcome.
Hey, any other questions for Commissioner Demi or Dale? Thank you both very much. Appreciate it. And again, if you can stay around as long as you can, I realize you both have appointments. The next witness is Judge Thomas Zoni.
Good morning.
Good morning, and this gives me an opportunity to say, yes, we're scheduling the next 3 Fridays for confirmation of judges at 11 a.m. And no, I would suggest they bring the same forms that they had to use for judicial nominating. We don't have special forms.
And
So if you would work with Mike Farrant and Peggy Delaney on the schedule for the 3 judges. I think you just 3 right now, right?
that's correct.
Yep. And if you just work with him, we're completely open to whatever schedule works for the judges.
All right. Well, thank you very much. I will facilitate that and see what works with Mike. So just
Okay,
for
great.
the record, Tom Zoni.
Now we can get on to the bill.
So let me just start out by saying, as I look at the bill, there are 2 provisions that look to be changed from what the legislature adopted last year. I recall Judge Grierson had discussions, as Mr. Crook points out, with our justice partners, as well as testified. I'm not going to revisit the policies that were adopted. I'm not going to revisit the extra work that it caused the judiciary, because I think that we're beyond that. As I understand it, the Senate is looking to address really the Locke decision and to make sure that its intent going forward is effectuated. Was there extra work? Yes. Did DOC act, as Mr. Cook points out, to try to work with the courts and identify matters? Yes. There was a large number that came in, and they were addressed. And as Senator White correctly points out, not everyone requires a hearing, because under Title 28, Section 251, unless there's an objection, there is a mandatory shall for the court to grant the discharge. So while yes, it's a lot of extra work for paperwork, there was the benefit that DOC was seeking and the legislature was seeking, to have individuals no longer, I'll use Senator Betting's terms, in the file cabinet being supervised. And when we look at these changes, the 2 changes the legislature is looking at, the court does support. If the legislature believes that it's appropriate to say that if you have pending criminal charges, that should not go forward, that makes sense. And so that's a change that I think DOC is advocating for, that we certainly would support. If there's a violation of probation, as they've noted today, that may also be something that the legislature develops as a policy, which would also address the matters coming in and the numbers. One thing that I would note, however, is, and Senator White was touching on this earlier today during the walkthrough, and it was, well, what happens to the cases before July 1st of 2021? Or she mentioned, what about that person in November? And I would hearken back to Judge Treadwell's decision, because his decision talked about a couple things. And on pages 9 and 10 of that decision, he also highlighted the fact that because the section talks about DOC's obligation to be evaluating it 1 month before the midpoint, if you have the statute come into effect and that 1 month period has already passed, his conclusion in his lot decision was that those individuals are not permitted to have midpoint review. In other words, under the lot decision, if that were adopted by other judges or found to be the law by the Supreme Court, as Judge Treadwell says, it would be a modification of the statute to allow anyone who's already passed the midpoint, that month period, to receive midpoint review. So if someone's, for instance, if someone's midpoint was today, and you made this statute effective today under lot, they would not be able to have midpoint review because DOC could not have complied with the mandatory evaluation 1 month before the midpoint period. And so I think if the legislature's intent is to say that individuals are entitled to it right now who might have, their midpoint might have already been passed, that would need to be very clear in order to address at least what Judge Treadwell concluded in his lot decision. Because I don't want to see the legislature come back next year and say, well, boy, that wasn't our intent. I think it'd be helpful if we made it very clear now. What do you do with those cases? For instance, right now it says the starting date would be July 1 of 2021 for the retroactivity, for retroactivity. If this were to pass, to be made effective upon passage, the only people under lot who would be able to get this midpoint review would be ones whose midpoint came up at least 30 days past the date of passage, if that makes sense. And so what happens to those individuals in that interim period should be addressed if the intent is to have them benefit from this midpoint review.
Senator Benning.
So, Judge, I was frankly surprised to read Judge Treadwell's opinion. I was under the impression he was with us having discussions about the intent of this bill in his previous role. And the intent of the bill is to get people out of the filing cabinet. Placing obstacles in front of them the way Judge Treadwell did seemed to be form over substance. And I totally agree with you that we need to be very clear about what our intent is and have that override somebody looking at a piece of the bill and deciding that that takes precedence over what the overall intent was. So hopefully we can come up with some language that will make that clear, even if they are beyond that point where corrections could have made a 30-day advance review of them. The intent is still to get people into this category of being eligible to be taken off of out of the filing cabinet. And I'm sorry about the background noise. The plow is going by. Thanks.
Well, you're relatively lucky, Senator Benning, that every time I was in a meeting with Senator Lyons, it was a plane going over, and it was quite the racket. So
She's always complaining about those F-35s.
I know they go right over her Zoom location. Anyway, Judge, did you want to comment? I mean, it seems to me the simplest solution is to not have a date there.
What the problem would still be under lot, I think, that even if there's no date there, Judge Treadwell's conclusion was that 252 D1 would be surplusage because it requires the Department of Corrections to do something a month before the midpoint. And if that period had already passed, there would be no ability for DOC to comply with that requirement. And so if you're looking to change it, one consideration may be to look at that section and maybe add language anytime thereafter for persons whose midpoint has passed at the time of passage or as passed at the time of the effective date of this section. Something like that could perhaps address that.
Other comments, Judge?
No,
Very
I have nothing further unless there's
Um,
any questions.
Yeah, I was tempted to ask Judge Treadwell, but because we like to hear from him,
Well, if you would like, I will
over
tell
the
you.
years,
that
but
actually-
we didn't, we chose to go with you.
Well, that's okay.
No, that's not an insult to you, sir, but
Oh, no,
you know,
no.
we have a long history with Judge Treadwell, long before he became a judge. He used to be in here as the deputy state's attorney in Chittenden County.
Well, I will
And his
share.
voice kind of lulls us, his
Yeah.
accent.
And we end up doing what he wanted because
Yeah.
of his accent.
Because
Well,
of his
if you'd like-
accent, it lulls us.
I've actually reached out to Judge Treadwell and I can send him the link if you'd like, and we can get him in here if it's going to help.
It might,
Mr. Chair, could I just ask another question?
sure.
Judge, the commissioner brought up the comment that a VOP was not necessarily considered a charge. I have always considered violations of probation as a criminal charge. Is there some difference of opinion there as far as the courts are concerned?
I would say that for clarity purposes, it should be differentiated between a criminal charge and a violation of probation, because the violation is not a Title 13 offense or Title 23 or 18 or one of the criminal statutes. So I would recommend that in order to avoid any potential confusion or lack of clarity, that it mention both. I think that would make it clear to all judges how it should be viewed.
Thank you.
Any other questions for Judge Zonay? Judge, thank you very much for joining us
Thank you.
today. We
Thank you for
appreciate it.
having me.
Evan Meenan, the deputy state. Keep saying deputy state's attorney, and I want to say representing the Vermont state's attorneys, the Department of State's attorneys and sheriffs.
Good
We know who
morning.
you are, you know. So, go
Good
ahead.
morning.
Good morning.
I'm glad you know who I am by now, but I regret that I don't have Judge Treadwell's accent. I feel like it would really help me out this morning. But
Yeah, well,
for the record, my name is Evan Meenan, and I am a deputy state's attorney assigned to the executive director's office of the Department of State's Attorneys. I'm hoping to spend my time this morning talking about two things. The first of which are the problems that the state's attorneys identified with Act 24 after it came time to implement them, and the potential solutions that we think could solve those problems. And then the second thing that I want to talk about is the retroactivity of these provisions, which should be informed somewhat in my participation in the Lott case, which I did litigate. So with regard to the first issue, I want to start off by talking about the numbers, and there's been some questions about that this morning. Prior to today's hearing, I did reach out to the Department of Corrections and confirm that between July 1st, 2021, when Act 24 became effective, and the middle of December, approximately 700 midpoint motions were filed. And to be honest, that was overwhelming to many state's attorneys' offices, because we only had 21 days to review each of those and determine whether or not there were grounds to object to the motions being granted. And that ate up a significant amount of time and resources for the Department of State's Attorneys. We identified three reasons that that was overwhelming for us. The first of which we already discussed a little bit, which is the fact that people with pending criminal charges were having these motions filed. The second is, and we've talked about this a little bit as well, is that the fact that people facing VOPs were also having these motions filed. And both of those situations seem somewhat counterintuitive to the state's attorneys. And so we appreciate that this committee is thinking about addressing those two issues. There was a third issue, however, that in our opinion made many of the motions that were filed unnecessary. And that has to do with the fact that Act 24 amended two statutes, but it did so in different ways. The first statute that it amended was 28 VSA 252. And what 252 does is it establishes when the Department of Corrections has to file one of these motions. And there was one standard in that statute that had to be met before the motion was required to be filed. The second statute that was amended was 28 VSA 251. And that statute has the standard that the court has to apply when deciding whether to grant one of these motions. The problem is that those two standards were different from one another, which meant the Department of Corrections was required to file a motion even if they and the state's attorneys knew that the standard that the court had to apply was not going to be met. The bill that I submitted to this committee in advance of today's testimony attempts to resolve all three of those issues. And I'll explain how it does that. With respect to criminal charges and VOPs, our proposal takes a slightly different approach than the draft bill that you're considering today. The draft bill that you're considering today would make it so that if there are pending criminal charges, DOC does not have to file one of these motions. The Department of State's Attorney's proposal is slightly different because a pending criminal charge and a pending VOP would not be an absolute bar to filing one of these motions. Instead, DOC would have discretion to file them. So, for example, let's say someone was on probation for lewd and lascivious conduct or a sex offense, okay? And then they subsequently get arrested for something like driving with a suspended license. Under our proposal, the Department of Corrections would be able to say, you know, the driving with a suspended license is not directly related to the reason why this person was on probation. So we think it's still appropriate to file one of these motions, and it would have the authority to do that. When the court receives that motion, it would then say to itself, okay, we have this pending criminal charge. We now have the authority to basically just track them together, put the motion for discharge from probation on hold, wait for the criminal charges to be resolved, and then we move forward with the motion. But at least the motion is filed and it's on everyone's radar and they know that it's an issue that has to be addressed. So a slightly different approach. Criminal charges and VOPs would not be a total bar, but it would be a factor that would get taken into consideration. Then our bill proposes to align the two standards that are in 251 and 252. So what Act 24 did was it said that one of the things that DOC had to consider was whether or not the probationer has completed, and I'm reading from the statute now, completed those rehabilitative or risk reduction services required as a condition of probation, which have, and this is the key part, a duration that is set and knowable at the outset of probation. Here's why that's an issue. For everyone who is already on probation, nobody would have been aware of this new midpoint review process. As a result, nobody was concerned about putting in the plea agreement or putting in the minimus or putting anywhere on the record the set duration of the rehabilitative risk reduction services. So what we were having happen is DOC was basically just filing these motions because it was saying, well, there was no term set for this. So that criteria effectively is satisfied. The standard that the court applies is slightly different. What the court has to determine is whether or not the probationer is substantially in compliance with the conditions of probation that are related to the probationer's rehabilitation or to victim or community safety. So what we propose to have happen is take that standard from 251 and plug it into 252. That way the standards are the same. And before the Department of Corrections has to decide whether it wants to file a motion, it has to look not at whether or not the probationer is in compliance with conditions where we knew how long they were going to last, the services were going to last. Instead, DOC is looking at, okay, is the probationer in compliance with those probation conditions that relate to rehabilitation and victim and community safety? And if the answer is yes, it files one of these motions. And it's the department's position that if we can make those three changes to the law, align the standards, and adequately take into consideration criminal charges and VOPs, that will reduce the number of motions that state's attorneys are legitimately objecting to and make this whole process much, much easier to manage. Because knowing that 714 motions was overwhelming, the prospect of 2,000 of them is daunting. The second thing that I wanted to talk about was this concept of retroactivity, because I did litigate that lot decision. And I do want to point out that it wasn't the state's attorneys that raised that issue. It was Judge Treadwell raised it and asked for briefing from the state's attorneys. And it turned out that he was correct to do so because under current law, Act 24 as written probably should not have applied retroactively. But that's different from saying the state's attorneys object to it being applied retroactively. But there's a couple of additional things that I think would need to happen in order to have it applied retroactively successfully. The first of which is the exact thing that Judge Zone flagged, that there was an alternative reason why this did not apply in the Locke case. And that was because even if it did apply retroactively, there was no possible way for the Department of Corrections to do the necessary review during the month prior to the midpoint because the person had already passed that midpoint. So Judge Zone is absolutely correct. If you want this law to apply to folks who have already passed their midpoint, you really should take a look at 252 D1 and that phrase during the month prior to the midpoint. The second thing that I think you might have to do is go back to Act 24 and the amendments that were made to 28 VSA 251. Because Act 24, as you recall, I just explained, it amended 251 to create the standard that the court has to apply when it receives one of these motions. So those changes to 251 also have to apply retroactively. So it would be insufficient in this bill to just make the changes to 252 retroactive. You'd also have to go back and make sections 3 and 4 to Act 24 retroactive as well. And although it seems like that's definitely the direction this committee wants to go in, I do want to just flag that one thing that you should consider before finalizing that policy decision is the expectations of the prosecution and also victims in how this might affect sentences. For example, when I was at the Attorney General's office, our routine practice was in child pornography cases, online sexual exploitation of children cases, we would forego asking for prison time in lieu of an extended period of supervision that required sex offender treatment. And the expectation was that the person would serve a good chunk of that. Now, under this law, it's likely that some of those probation terms might get cut in half. So I just want to flag that as food for thought before you finalize any policy decisions. And with those points, I'm happy to answer any questions that folks might have.
Well, I'm kind of stunned because I think you took a simple little bill and complicated the hell out of it personally. But maybe that's my misunderstanding of what you're trying to do. I think clearly there should have been consideration, and it was our intent that people who had pending criminal charges and pending violation should not be eligible. So I kind of think that C takes care of that with the addition of pending violations. I guess my question becomes this issue of retroactivity. And yeah, I'm reminded that I hear about the workload and I hear all of that, but I don't hear any comments about, I think it's roughly $16 million in ARPA funds that was put into the court, put into the state's attorneys, the defense, and others to try to help with the backlog. So I want to make, that statement clear. That was a decision this committee made and the Appropriations Committee adopted back last year when we were dealing with the budget. So that I don't know what happened there, but it should help to stem any problems. And if there are, then I need to better understand them. I am totally confused by your I guess I'm not clear. It's not clear to me. There are two issues. One is how do you deal with retroactivity? And I think I need advice from our legislative counsel on the best way to deal with that. The goal of the bill is the goal of the original bill was to get people off probation and who didn't need to be on probation any longer. That was the recommendation of the Justice Reinvestment 2 working. Second, but this bill is, as introduced, is to try to deal with problems that developed, including the lot case and the retroactivity. So we are clearly all in agreement that we need to deal with retroactivity. It's just how we deal with it. Is that correct?
Yeah, that's absolutely correct. And my goal was not to take a simple bill and overly complicate it. My comments about retroactivity are designed to flag that on the bill, page 2, lines 18 to 20, that will not be sufficient under the Lott decision to make this law fully retroactive.
Right.
And 2 additional changes need to be made. The first is the change that Judge Zone flagged about the language in 252 D1, the phrase during the month prior to. And then the second change is to make Section 3 of Act 24 also retroactive. Because otherwise, the statutory provisions that require DOC to file the motion will be retroactive, but the statutory provisions pertaining to how the court reviews those motions would not be retroactive. And then my comments about, trying to address some of the other issues that we confronted, I think with regard to pending criminal charges and pending VOPs, the department's proposal is actually more permissive than the bill that has been drafted and that you've reviewed, because we're not making pending charges and VOPs a total bar to filing one of these motions. So it actually is more permissive. And then the third comment is really just designed to say, let's make the standard that DOC looks at when deciding whether to file one of these motions as close as possible to the standard that the court has to apply when deciding to grant a motion, to minimize the instance when DOC is filing a motion that it doesn't even think should be granted. For example, the standard that DOC has to apply does not include a reference to victim or community safety. So let's say that there's evidence that there's a condition of probation that prohibits the probationer from contacting a victim, and there's been repeated violations of that condition. Arguably, DOC might still have to file one of these motions, and then the Department of State's attorneys would have to object to it and say, well, wait a minute, the probationer is not substantially in compliance with the conditions related to victim safety, and then we would have to have a court hearing unnecessarily.
That's helpful. Senator White.
So I have to say that I really like Evan's proposal around the pending criminal violations or violations of probation, because there are technical I mean, the example you gave is, it isn't a technical violation, but there are technical violations. And if somebody doesn't show up for their appointment and the probation officer decides to file a violation, because that is, then that means that that person isn't eligible. And I really like the making it a little more discretionary than a complete bar. I think that that makes perfect sense.
Other comments, questions for Evan? Thank you all very much. We're going to take a 10-minute break and be back at 20 after. That's
Before we
possible.
break, can I ask Evan if that's a beet on your wall?
Looks like a strawberry.
Well, it
is
is,
a-
but the one beside it is a beet, I think.
Oh, I see.
I do, yes. There's a strawberry and a beet.
My favorite vegetable.
All right. Well, we come back at 11. It's right now it's 10:11. So we'll come back